Welcome to Workers' Comp Update with Joseph Sensale. Joe is a partner in the Chase Sensale Law Group and is also treasurer of the New York Workers' Compensation Alliance, dedicated to serving the needs of injured workers throughout New York State by lobbying their interests in Albany.
Joe, now that the schedule loss of use guideline issue has been, for the most part, resolved, has anything significant happened this year in the world of New York State workers' compensation?
Steve, it's funny because it's always in turmoil. So to answer your question in short, yes. And I can give you some of the things that have transpired since the beginning of the year. The first thing that is significant is that we still, despite the schedule loss fight, we still participated in a lobby day. That's when groups of attorneys and that are members of my organization, the Workers' Compensation Alliance, will travel to Albany from all over the state and speak with legislators in Albany about the next pressing issues. And there is always something on the horizon. I think I may have mentioned in the last podcast that two of the things that we strongly lobbied for, and we seem to have gotten some support, which is always important, is something called the labor market attachment legislation. And what that means is that if you have an injured worker here in New York that has a partial disability, and it's been adjudicated as a partial disability, or the individual's own doctor says that this disability is partial, meaning that they can perform some sort of work, it's up to the individual judges and the court to decide whether or not that individual has to remain attached to the labor market, which in colloquial terms means going out and looking for work. You get different results with different judges, different parts of the state. So what we as an organization are looking to do is have legislation proposed and hopefully enacted that would give a statutory scheme as to the requirements for someone in that situation to look for work. Right now it's up in the air, and it could affect somebody's ongoing or continued benefits. And it could, like I said, vary from judge to judge and from area to state to area to state. You wouldn't think that because it's one body of law that's the same throughout, but there are inconsistencies, and that's one thing that we're looking to correct. The other thing is the presumption for permanent total disability if an individual is receiving Social Security disability benefits. So in other words, if the federal government, which administers the Social Security benefit, deems the individual to be totally disabled, then that should translate into a presumption in the New York workers' compensation system of a total disability as well, which can be rebutted by the employer if they can show that the reason why the person is unable to work has to do with something other than their disability. In short, I'm oversimplifying it, but that's pretty much the concept. It would just save a tremendous amount of litigation because, again, if you have the same criteria by another administrative agency, which would be the Social Security Administration, granted it's not New York specific, but if that body has already adjudicated that the individual, based on medical evidence, is and the claimant's testimony and testimony of anybody else for that matter, that the claimant can't perform any kind of work at all on a permanent basis, then save the litigation here in the New York courts and not develop the issue that's already been adjudicated. But again, like I said, it would be a rebuttable presumption so that the employer or the carrier, insurance carrier, isn't prejudiced rather with respect to that. So we're looking for that as well. And those are the two things that we seem to have gotten some strong support for from various state assembly people and senators. So that we considered Lobby Day a tremendous success. And we also thanked our elected representatives for their support during the whole schedule loss abuse fight, which I can only tell you, like I said, most of it has been resolved. There's still little aspects of it that have to be dealt with. You and I would be having a much different conversation if we weren't able to successfully defeat those proposed regulations as they were proposed by the Workers' Compensation Board. There is one other thing, and that there's a proposal to have law students represent injured workers before the Workers' Compensation Board that are neither what we call licensed representatives, meaning that they passed a certain certification to do that, or are attorneys. And not that I have any qualms against law students. I was a law student once myself. However, what is cautious, what you should be cautious about, these law students will be working under the umbrella of the Workers' Compensation Board. So immediately you have to scratch your head and say, well, if the Workers' Compensation Board may be in control of people who are representing injured workers, then where is is there a denial of due process? Is there a conflict there? I believe the comment period, in other words, we interested parties have until I believe July 23rd to submit comments on that regulation to see whether or not it should be something that's viable. Again, the big thing to us that sticks out is that if you're an employee of the board, it seems rather inconsistent then to be able to represent people before that entity. So that, and we'll have a position paper. My organization will publish that, and we'll see where that goes. So I'll follow that up with another podcast as well as everything else for that matter.
In terms of judicial issues, has anything else arisen?
I'm glad you asked that, Steve, because I could tell you that the issues I discussed earlier are more of a legislative type issues, but there is something before the judges here at the Workers' Compensation Board and the Workers' Compensation Board itself, and that concerns medical marijuana. The issue is whether or not there should be authorization for payment for medical marijuana for treatment of certain conditions. The federal position is that there is no allowance for that, and I'll give you the exception in a moment. But in New York, there's the New York public health law that says that if you have chronic pain and you're diagnosed with chronic pain, I guess there's substantial evidence to support that, then under the New York public health law, medical marijuana is something that can be recommended as a treatment. The individual that receives it, the injured worker, as long as it's administered by a doctor or under the New York State program for it, there wouldn't be any federal interference with that, even though the federal position is against it. Under the amendments to the budget bill that was just extended back in March for another 6 months, the federal funds could not be used for the prosecution of use of medical marijuana, the distribution of medical marijuana, if it met the criteria of the New York public health law. So despite all that, though, two things have to be considered. One, that the extension for 6 months from March of this year would end in September, and whether or not that is going to occur again is up for political consideration. So it's not fixed in stone that the allowance for it by the federal government, that is the prevention of prosecution for this type of thing here in New York will continue. And if you notice, it's done via the budget. So the federal government can't use federal funds to prosecute. This is a way to avoid an issue where you would have to make an exception for, say, New York or whatever other state that is permitting this. So, but by denying them the funds, they can't do it. So that's a clever way, I think, of maintaining the position that medical marijuana is legal, and marijuana use at all is illegal on the federal position, but still in New York, it wouldn't be prosecuted because they wouldn't have the money to do that if it's for medicinal purposes. But the Workers' Compensation Board, despite all that, seems pretty reticent. In my own personal dealings with judges, I've seen that they are not overly enthusiastic to authorize payment for medical marijuana until something definitive comes from either the federal government or some other source to indicate whether or not that's something that they would feel comfortable in doing, and that is authorizing payment for it.
So is there anything else in the news, Joe?
Well, two things, yeah. I mean, one involves a United States Supreme Court case, and I'll discuss that in a minute. But local news, meaning local to New York, the Albany Times-Union, which is the newspaper of record up in Albany for political dealings, reported that they expect employer costs, and that is workers' compensation premiums, to decline by 11.7%, which is twice what it declined last year. That rate decrease must be approved by the state by July 15th. So it begs the question, if there's these massive reductions in premiums for workers' compensation benefits, why has there been such a gung-ho fight to erode the statute, and either through the regulations like the schedule loss fight that we had, or other things that are prevailing, such as judge-made law, like with the labor market attachment issue? Why is there such a push to eradicate or erode the statute in some instances? And the answer is, I don't know what the answer to that question is. I guess we'll find out as things develop. And if the rate is approved, I mean, the cost, I mean, a drop of 11% is significant. And again, and what that simply means is that any interested party that is paying into the system, what I mean by that is insurance carriers, they're going to have to charge less than for an employer for workers' compensation benefits. So employers will see their costs drop, but will the profits of the insurance company change their position on certain things, or will the fight eventually end and the statute will be kept at a status quo for a period of time? We'll see. We don't know. But again, something else that's going to be interesting to speak about in a subsequent podcast. The other issue is one that's quite large as well, and involves a Supreme Court decision that got held in abeyance, so to speak, upon the death of Justice Scalia. Now that Justice Gorsuch is on the bench and will be participating in this decision, we expect it to come out shortly. In fact, it could be coming out as I'm talking to you right now from the Supreme Court, and that is the case of Janus versus Asks Me. What the premise of that case is that the issue of whether or not it's violative of the First Amendment to have union members pay agency fees to the union, which, in my understanding, is equivalent to union dues. But they would still reap the benefits of whatever the union negotiates. So in other words, if you're a union member, you could say, I'm not paying union dues because some of the positions of the union are against my I don't agree with them and it violates my First Amendment beliefs, so I'm not paying those dues. However, if there's a collective bargaining agreement or an issue that has to be dealt with by the union itself, and this, I should say, involves public sector unions, that individual will still reap the benefit without paying into it. So what effectively will happen, in my view, is that it will effectively bankrupt any union because they won't be able to collect union dues. And as a result, the individuals that were members of the union will not gain any benefit whatsoever, and it may very well eliminate the efficacy of any kind of union activity. And that, of course, hits home with us in New York in terms of workers' compensation, although I've been told that New York has made certain provisions to prevent any kind of detrimental effect from this decision. I think that remains to be seen. So it could affect people in public sector unions. And who am I talking about? Police officers, firemen. I'm talking about people that work in the public sector and have unions to protect them. They may see their union benefits erode away, if not vanish completely. So it is a big deal here in New York. And I know that there's certain legislative things that have been done on that front to try to minimize any impact here. But we don't know what that's going to be. And that decision should be coming out very shortly.
Thanks for listening to Workers' Comp Update with Joseph Sensale. Joe is a partner in the Chase Sensale Law Group and is also treasurer of the New York Workers' Compensation Alliance. Join us next time as Joe keeps us updated with what's going on in Albany.